Alrighty, good evening, everyone. Welcome to week 8 of administrative law. Hope you've all recovered after the big advocacy week last week. It was really good to, have you all make your presentations and overall, yeah, I was very impressed with the standard of work that was on display. So well done. You should all pat yourselves on the back for that one. That was really good to see. I'll spend the first probably 15 minutes of tonight's tutorial talking through the next two assessments. So the reflective discussion task, which is live now, and then the end of term take home exam. Obviously, there'll be plenty of other opportunities to talk about the exam over the next few weeks. But what I want to do in tonight's tutorial is talk through some of the, I suppose, tips or strategies for what you can be doing now and over the next few weeks to prepare yourselves as well as possible um, for the exam. So things that you should be paying attention to um, with your note taking and being really strategic with your study so that you're as efficient as possible. Because I know that you know, everyone's got a lot of things going on in their lives. So yeah, sort of helping you make the best use of your time and so that by the time you get to the end of term, you've got a really nice and really useful set of notes to go into the exam with. But before we do that, let's talk about the reflective discussion task. And as I say that, I'm looking at it and I'm seeing that the task sheet may not have actually made its way onto Moodle there. So I'll double check and if it's not up there, I'll add the task sheet to Moodle after this. The task description itself is all there. It tells you everything you need to know. But the Word document version has just got a couple of examples as well that you might find useful too. So I'll make sure that's up there. But basically, the idea behind the reflective discussion task is there's a forum under the assessment tab in Moodle now. And what you'll do, you'll go there and you'll make two posts in that forum. The first is a reflection on the advocacy task that you just did. And then the second post is a reply to someone else's. There's no fixed word limit, but aim for about 200 words each. It's only worth 10%. Don't spend hours and hours and hours crafting an entire novel. Just focus on, something that's succinct and to the point and says what it needs to say. And then, you don't necessarily have to spend any more time on it than that. There's the overall uh, the overall aim for this task is twofold. The first is very practical in that it's a condition of our accreditation that you engage in a group discussion environment as part of your assessment. So that's this pathway rather than tutorial participation marks and that sort of thing. But more importantly, this assessment task is a really good opportunity for you to think about the advocacy experience and the group project experience, whatever it might be that you choose to reflect on, but really actually spend some time examining what went well, what didn't go so well, and actually thinking about why that might be and trying to really distill down some important lessons about how you can take that forward into future assessments and maybe beyond, even into legal practice. And so, you know, just a few examples. I sometimes people will say they'll reflect, oh, I missed this particular case that I should have talked about, or I completely blanked on that section of the Freedom of Information Act. I should have thought of that, but I didn't. Next time I'll make sure I cover everything that I need to cover. And it's like, well, that's, it's good to have had the self-reflection to identify that. But at the same time, that really doesn't tell you anything, because when you move on to the end of term exam, when you move on to another subject, how will you know what the things that you needed to cover were to make sure that you covered it? How will you make sure that you haven't missed anything when almost by definition you don't know what you've missed until you've missed it? So in this task, we're looking for something more than just those surface level, I made a mistake and next time I won't make the mistake. Actually think through, well, what were the steps that led to that mistake? Why did you miss that provision of the FOI Act? Um, did you just not read through the act or the question thoroughly enough? And moving into the exam, one of the things that you really want to work on is paying attention to the details. Was it you actually thought of it and you initially had crafted a response, but when you were trimming your response down, you thought, maybe that's not quite relevant, and it got cut. And so, what was the thought process behind deciding what's relevant and what's not, and how can that inform future assessment? So doing more than just I'll do better next time, or I'll do things differently next time. Actually identifying some really concrete insights into why the thing happened this time, and then how will you learn from that for next time? What are the steps that you can take to make sure that happen? It might be a positive thing as well, right? Often people will talk about how great a partner they had for the advocacy task. I really liked my partner. They were so supportive. I was so nervous, but they did a great job talking me through it and calming me down, or whatever it is. Again, that's a great insight. And it's great that you had that experience. But beyond this assessment, beyond this unit, what does that tell you? How does that inform the way that you go about things? It doesn't really. But if you can say, oh, look, my partner was really great. They were upfront with their communication. I really felt like they listened to me. When I said that I was nervous, they didn't just brush me off. They actually took the time to talk through what I was nervous about, and it felt really good to feel like I had someone on my side. The next time I have a group assignment, I want to be that person in the group assignment. I want to be a person who is really actively communicating and really making sure that my partner feels listened to, and those sorts of things. So just really boiling down, okay, what were in your reflection, whether it's a positive or whether it's a negative, focusing on the specifics and then incorporating that into something that's a bit more actionable, or something that's more tangible that you can incorporate as a lesson for future assessments, whether that's the end of term exam, whether that's for another unit. So that's the first post, the reflective, the reflection. You also then have a response to someone else's reflection. And again, what we're looking for here is an attempt to really understand and engage with your peers, your colleagues, in a supportive way. And so, one of the things that tends to do well is where people respond to someone's experience, one, with being able to relate. I had a similar thing happen to me, or I was nervous too. Here's something I did that worked really well to help with that. So, I was really the original post is, I was really nervous before the advocacy thing. I've never done anything like this before. The response, hey, I hear you. I was really nervous as well. But I did a practice session with my partner, and we found that that really helped. Just practicing presenting to another person via Zoom, that really helped settle a lot of my nerves. Or I went on YouTube and I saw a bunch of mooting videos, and that just helped me understand what the expectations are, or confirmed in my mind what it was going to look like, whatever it is. So something that engages with the original response, but extends it in some way, and has some attempt to, I guess, add value or promote a sharing of knowledge amongst the cohort. Really, that's sort of what we're aiming for in this assessment task. And then, by the end of that experience, hopefully you've got something from within, something that you yourself have generated that you can do for next time. And also you've heard from someone else and learned from someone else about something else that you could do, or that works, or that worked for them, that you might like to try, something like that. So, the entire assessment experience is designed to consolidate what's happened in the previous assessment task and think about, okay, moving forward, what are we going to do? What do we take from this? How do we learn? Any questions about the reflective discussion task before we move on to talking about the exam?
Jacob, is there a marking guide for it or a rubric?
There's not a rubric. I'm just checking the so there's 5 marks per comment, so 5 for the original and 5 for the reply, and it's based on the quality of your reflection and the constructiveness of your comments towards others. So there's not a fixed, because it's only worth so little, there's not a really detailed breakdown of each, but reflections and responses that capture the ideals that I've just set out will do well and will score closer to the 10. Responses that are more surface level, that don't sort of identify those concrete steps and tangible lessons, and that will do less well. Any other questions? No worries. So the other thing I wanted to talk to you all about is the exam, which, I appreciate is not for a while yet, and you've got a fair bit of term to get through before then. But I did want to talk about a few things that you can be doing now to make sure that you're as prepared as possible come February. So first thing is to organize your student ID or student card if you don't have one already. Most of you, I think, will have now been through the online invigilated exam experience from last term or the term before. But for those who haven't, it's this is an exam that you can that you'll sit while on Zoom with your camera on, with your microphone on, so that you can be invigilated. And as part of that process, you will need to show student ID at the beginning to identify yourself. So don't get caught up in the week 12 exam week rush through student services trying to get a student ID. If you don't have one yet, now is the time to put those forms and applications in, so that you've got that ID well before exam period, because that's just a layer of extra stress that you don't want to be dealing with come exam week. So first practical step, get your ID. The second thing that I want to be thinking about is how you should be engaging with the study materials over the next few weeks, so that you've got a useful set of notes that you can be building on and practicing working with, so that by the time you get to the exam, you know your way around them. Hopefully you know the material well enough that you only really need to look at them to check specific things. And in a broad sense, you already know everything. And practicing being able to present answers. And so one of the things we've talked previously about, you already know what the questions on the exam will be, right? Question 1, is judicial review available? Question 2, which grounds of review are relevant or are likely to be successful? Question 3, what are the remedies? Or what remedies should the client seek? And those 3 questions cover everything from week 5 to 12. So it's I'm not really narrowing things down all that much for you in telling you that that's what the questions are. But we've talked before about question 1, is judicial review available? You can have really good notes preparing all those elements of judicial review availability that we talked about in week 5 and that we've been practicing in these tutorial questions over the past few weeks. We're in the heart at the moment of question 2, right? Grounds of review. Which grounds of review are available, and or which ones would have a good likelihood of success? What I'd like you to be thinking about as we go through these grounds of review in the next few weeks is, for one, obviously just doing as good a job as you can at getting familiar with the material, familiar with the tests and cases, and understanding when they're likely to apply, when they might not apply. But the ideal that you want to get to in your notes is to come up with a little script for yourself that you can use in the exam that talks through the key ideas, principles, tests, cases, whatever it is. And if you think about, I don't like IRAC as a structure necessarily, but if you think about the basic IRAC format, the rules, that sort of doesn't really change depending on the scenario. All the variation is in the application. So theoretically, for any given topic, you can have the rules section of an exam answer already written by the time you go into the exam. And from the perspective of trying to be as prepared as possible, trying to be as efficient as possible with your time in the exam, do as much of the exam beforehand if you can. And so we'll talk through over the next few weeks some specific examples of what those sort of scripts might look like. But for now, and preparing over the next few weeks, I want you to be thinking about what are the different rules and tests and cases that we're talking about, both in the lecture materials and in the tutorials, and how much of this can I pre-write? How much of this can I prepare for myself already? So that by the time when I get to the exam, I've done as much thinking prior to the exam as possible. So, for example, tonight or this week's topic, looking at unauthorized decision making, specifically where there's a jurisdictional error. You know, when you're thinking about this topic, that we're thinking about distinguishing between jurisdictional and non-jurisdictional facts. You know that we're thinking about, okay, what are the boundaries and limits of the decision maker's authority to decide, the jurisdiction? Is this a scenario where the decision maker has the authority to decide whether the precondition exists or not? Or is this something that is more external, objectively determined? You can have yourself a little paragraph written up about those ideas, discussing the difference between a jurisdictional and a non-jurisdictional fact, identifying that judicial review will be available if we've got a jurisdictional fact. And then all you need to do if the exam scenario includes something along those lines, all you need to do in the exam is actually just do the application and say, here, we've got a jurisdictional fact. Section 5 says blah, 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 blah. Or Section 6 is worded in such a way that the decision maker has discretion. The minister must be satisfied. Or the secretary, if the secretary forms the opinion, this is wording that tells us that the decision maker the decision maker's jurisdiction in this space is not judicially reviewable, right? So there's so much thinking that you can do now and over the next few weeks that you don't have to do in the exam. So we will talk over the next 5-6 weeks, however long we've got to the exam, about all this, and this is certainly not the last conversation we will have about the exam, but I wanted to spend a bit of time tonight because I want you to be in a position over the next few weeks to be as strategic with your time as possible. And I think that the best way to prepare is, one, to obviously try and get familiar with the material and learn it. But as you're taking your notes, think about, okay, how can I actually use these as usefully as possible in the exam? And if you've got the time, if you're willing to put in the time, and you're organized enough, if you're doing it before the tutorials, you can actually test run your notes against the tutorial questions. And there, once you start doing that, you'll be able to refine your notes as well. You'll realize, oh, okay, I'd pre-written that, but it seems that it actually doesn't quite apply as easily across different scenarios as I thought. I better tweak that. Or, oh, wow, once I actually, wrote out an answer to this tutorial question, I realized that this whole paragraph will apply no matter what the scenario is. I'll put that in my notes. So being as organized as possible, if you can, I think is really important and really useful going into the next few weeks. So any, I suppose, broad questions about the exam? As I said, we'll talk in a lot more detail as we go through over the next few weeks, but anything at this stage in the term that anyone wanted to clarify in their minds about the exam?
Have you got a breakdown of the marks, Jacob, on what each section's worth?
I do. Trying to remember what it is. Question 1 is 12 marks. Question 2 is 23. Question 3 is 10, and then 5 marks for communication. And I think that adds up to 50.
Thank you.
That's all good. So, even that, you can see the bulk of your thinking should be on grounds of review, because it makes up so much of the content that we're discussing in this unit. Any other questions? No, that's all good. As I said, we've got plenty of time to think about the nitty-gritty of the exam as we go through. Let's talk about jurisdictional and non-jurisdictional facts. It's a tricky one to get your head around, and it's I think it really represents admin law quite well, in the sense that when you first think about it, it feels like a mess and it doesn't make sense. But once you have the aha moment and figure it out, then looking back, you'll think, what was I ever worried about? So just if you're in the phase of this doesn't make sense, that's okay, that's normal. You will get there. And if you're feeling lost, obviously reach out and we work through it. But once it clicks for you, it's the kind of thing that actually is, one, makes a lot of sense, but two, is really easy to spot. And so once you are getting to an exam scenario, you will hopefully be in a position where you're actually really easily identifying, okay, these are jurisdictional facts. These are the kinds of things that we can pursue judicial review on. Here's non-jurisdictional facts. We can't challenge the authority. We'll have to look at something else in terms of the judicial review availability. So that's that sort of caveat applies, and there's a reason why this term I've split jurisdictional facts out into its own week, just to give you that little bit more breathing space and a bit more time with it to spend thinking about it. So the key thing, and I think I've talked about it in the lecture material, so I won't belabor the point, but the key thing is that you want to be focusing on looking for the parts of the legislation where the decision maker has some kind of discretion or authority, and it's not discretion or authority to decide what to do. It's the discretion or authority to decide whether to act or not in the first place, and really being clear. So typically the way you see it expressed is at the start of a section or a provision. So, if the minister is satisfied that, if in the opinion of the authority, this, that's where we're identifying non-jurisdictional facts, and we're deciding, okay, we can't say they didn't get to make that call whether to act or not. We're looking for some other avenue or different ground of review. Conversely, if we're missing that section, if we're thinking about if there is a breach of a regulation, or if the applicant meets these criteria, something like that, where the decision maker doesn't have that level of discretion and or flexibility, then we're thinking, okay, we've got a jurisdictional fact, and that's great for us because we can review those. And so if there's an issue with that threshold condition of whether the decision maker could spring into action effectively, that's great. And so we really want to be on the lookout for these jurisdictional facts if we can find them. We'll talk through that in practice in terms of the tutorial questions, but did anyone have any sort of questions on the week 8 content itself before we press on with the tutorial questions? No, that's all good. So let's start by quickly revisiting last week's scenario. So last week we talked about Poe and the gaming investigation, and we identified potentially some problems with the decision maker's authority based on whether or not they followed the right procedures, and then also potentially whether or not the action that they took, so the decision to require a termination of employment, whether that was something that actually could be done under the Act. Now let's sort of, in some ways, we're taking a step back and we're asking ourselves, were they actually authorized to intervene in the first place? Did they have the authority to make any kind of a decision in this space? So I know from our discussion last week that some people had some thoughts at the time. Hopefully, I mean, I know that in between then and now, you've all had your midterm assessment as well. So time to think about admin law tutorials has probably been a bit limited. But let's open up to some discussion about whether we think the decision maker had jurisdiction or not to engage with this disciplinary action. So,
Okay.
sorry, go ahead.
I guess the first thing that pops out to me is that we don't actually have any information on whether the authority provided 28 days notice as required by section 26.3.
Right. So that's something that we identified last week about in terms of potentially being a problem with not following procedures. Are you suggesting then as well that that might be create an issue with the decision maker's jurisdiction?
Well, possibly if that's a requirement for them to initiate disciplinary inquiries, if they've not followed that procedure, they might not have been authorised to conduct the inquiry.
Yeah, I can see that. So where if section 26.3 is set out in a way where the decision maker's authority to take disciplinary action is contingent on the notice, then if they didn't provide the notice, they didn't have the jurisdiction, they didn't have the authority. I can see that argument. Yeah.
Yeah, mainly because it says they must provide as opposed to they may provide. So with 26.4, it says they may announce themselves. So that will be up to conjecture whether, okay, they might not have to announce themselves, but they do have to provide 28 days notice. Now, they might have provided that and that information has just not been given to us in the facts, in which case they could well be within their rights to conduct the inquiry on the night that they did. But that we don't have information in the facts. So that could be one avenue to explore.
Yeah, it's definitely an approach to take in terms of the decision maker lacking authority because they didn't follow a mandatory procedure. I can see the argument around jurisdiction as well. And to an extent, we're running up against an issue that we will come back to throughout admin law in terms of the boundaries between these different grounds of review and even the sort of sub elements within the grounds of review are a little bit blurry and there can be a bit of overlap. The main thing that I would focus on is I'd take as the starting point the action or the decision that the decision maker took. So in this instance, the decision to say these people's employment needs to be terminated. Start there and then work backwards in terms of what are the preconditions for taking that action. So in this instance, they then need to, we're thinking specifically about section 29 and section 27. And then even further back, then we're thinking about the issues around section 26, those sort of procedural issues that you're talking about. I think once in our discussion, we focus on section 27 and 29, we'll see that there are potentially problems there that are enough that mean that we don't need to loop into section 26 as well. Certainly in terms of procedural issues, that's we're approaching it from the other end and that makes the most sense. But when we're thinking about jurisdiction, working backwards, we'll find problems before we need to resort to that and to be as efficient as possible, focusing on that will make more sense. Craig, you've got your hand up.
Oh, yeah, sorry, Jacob. I thought initially that the language used in section 29 is indicative because it uses words like the authority may, if satisfied there are grounds for taking disciplinary action against a licensee, undertake certain language, and that language indicates that authority must first form that necessary opinion that one of the grounds listed in section 77 exist before the authority takes any further action. And the correctness of the opinion of the authority in that regard is not really a matter that a court can review. So it's a non-jurisdictional fact
Yeah.
applying Anvil Hill
Yeah.
project and Minister for the Environment and Water Resources. Yeah,
Yeah, absolutely. So
but
when, sorry,
I
keep going.
didn't go back. Yeah, sorry, I might have missed something, but I didn't go back to the section 26 on that, so I may have missed something there.
Yeah, no. So looking at section 29, and I'll share my screen just so that everyone can see the wording and the language that's used. So section 29, the authority may, if satisfied that there are grounds for taking disciplinary action, can do one of the things. And in particular, in our scenario, they've gone with, or they think that they've gone with D. We talked last week about that may itself be problematic, but the focus on if they're satisfied that there are grounds gives the authority the opportunity, the authority, the jurisdiction to decide whether there are grounds for taking disciplinary action or not. And so what that means in effect is that it's not open to us to say the authority couldn't have decided that there are grounds for taking the disciplinary action. We might, and this is thinking about different grounds of review, I mean, we might challenge that issue in other ways. So thinking, we've talked previously about no evidence. If we thought that there was no evidence to satisfy the authority that there were grounds, we could go down that route. But thinking specifically about the authority of the decision maker, it's not open to us to say the authority doesn't get to decide if there are grounds for review or not. The statute specifically puts that in their hands to make that call, to decide if there are grounds or not. The complicating factor is that section 27 decides or outlines what the different grounds are. And these are, well, A and B are expressed in much more objective language. So the licensee being charged with or convicted of an offence, the provision contravening a condition or restriction to which the license is subject. Again, very easy for an external party to see whether that has or hasn't happened. C is tricky because C is also giving us a lot of giving the decision maker a lot of authority. The licensed venue is or has been managed in a way that makes it desirable that action should be taken against the licensee. What does that mean? The decision maker gets to decide, right? Is it desirable if the licensed venue is just doing something that the decision maker doesn't like or thinks is problematic? Is it enough that the decision maker looks at the licensed venue and says, yeah, they seem a bit dodgy. I think we'll need disciplinary action here. It's desirable that we get involved and take a look at things. So it's the wording in 27C is broad enough to sustain so much action by the decision maker. And then on top of that, section 29, giving the authority this discretion to be satisfied that a ground for disciplinary action exists. From the perspective of judicial review based on an authorised or unauthorised decision making, sets the bar really high for us and makes things really tricky for us. Does that make sense? Can we see sort of where that is coming from? And so when we think about section 26, we've said that procedurally there have been issues. But approaching it from the other direction and thinking about what the decision maker is or isn't authorized to do in a jurisdictional sense, the scope is so broad that it makes it really difficult for us once they're kind of in the system, once they're in a position to be thinking about taking disciplinary action. The statute is worded so broadly that it makes it really hard for us to pursue judicial review under that ground. What I'd like us to do is jump into question 2, because it sets out the examples in a little bit more detail. And I will share my screen because in reviewing the scenario today, I realized that I hadn't given you a crucial bit of information that you need. So my apologies for people who tried to do this in advance. I made it very, very difficult for you. But so question 2, we've got George who buys and sells rare collective items, and there's 4 items that he's bought recently. He's got some Pokemon cards from Japan, a Quran from Jordan, a gun from the US, and a coin from England. All 4 of those items get seized by Border Force, and they set out some reasons for that. So the Pokemon cards and the Quran, Border Force say these are from restricted countries, so you can't bring those in. We're having them. And then for 3 and 4, the Border Force officer formed the view that they're a prohibited import under Section 67. What I forgot to give you guys was Schedule 1, which lists restricted countries. So in terms of items 1 and 2, that made that very difficult. So we'll talk through those first. But basically, George is coming to us for advice about, okay, well, what are we going to do about this? Let's skip our discussion of judicial review availability and assume that it is. Let's talk about items 1 and 2 first. The Pokemon cards and the Quran, which are apparently problematic under Section 52 of the Act as being coming from restricted countries. So just keep in mind. So Schedule 1 sets out the restricted countries. Jordan is listed, but Japan is not. So keeping that in mind. When we think about items 1 and 2 and then Section 52, what's leaping out to us as being useful and important and relevant here?
Where the items came from.
Yep.
And whether they form part of the Schedule 1 list of countries.
Yep, absolutely. So the key, really, the only difference of any importance between the Pokemon cards and the Quran is where they came from. And thinking about the difference between them, one of them has come from a restricted country, the Quran from Jordan has, whereas the Pokemon cards from Japan have not. Is Section 52 worded in a way that gives the decision maker discretion or not?
Looks like it because it says they may be seized, not that they must be seized.
Okay. Yep. So that's a good point. So there's the discretion, or there's the flexibility around what to do. And if we think about the kind of that classic formula of if X exists, Y may do Z, Y being the decision maker, Z being the action, X being some jurisdictional threshold or potentially a jurisdictional fact. So you're talking about discretion around Z, right? what the decision maker may choose to do. And they've got options. They can choose to seize it. They can choose not to. That's absolutely right. What about thinking about X? So this precondition of the import being from a restricted country or not. Is there flexibility or discretion there?
No, there isn't.
No, right? So it's the country is either on the list or it's not. It's either a restricted country or it's not. And the border force doesn't get to decide if a country is restricted or not, right? And so when we're thinking about the difference between jurisdictional and non-jurisdictional facts, when we're thinking about what does the decision maker's authority include, it includes the decision about, okay, what are we going to do with a good that's from a restricted country? But it doesn't include deciding whether the good is from a restricted country or not, right? That's got this element of externality or objectivity to it, right? So when we think about the comparing the Pokemon cards from Japan, they're from Japan. Japan's not on the list. So we can say this is a jurisdictional fact. This was a jurisdictional error. The border force acted as if they had jurisdiction, which would have been triggered by the import coming from a restricted country, when in fact they did not. It wasn't from a restricted country. They shouldn't have been even thinking about whether they could seize that import or not. There was a jurisdictional error. There was a problem with the decision-making process. And so item 1, the decision to take the Pokemon cards, invalid. Compare that to item 2, the Quran from Jordan, which is listed under the schedule as a restricted country. That means that the decision maker is operating in an area in which they do have jurisdiction. The act says to them, you've got, you can decide to seize something if it's from a restricted country. This is from a restricted country, therefore it's fair game. You've got the authority, you've got the jurisdiction to make a decision in this space, and they've decided to seize it. So item 2, the seizure of the Quran, valid, at least from a jurisdiction perspective. Does the distinction between those two make sense? You can see, the threshold element of is it from a restricted country or not is not in the decision maker's hands. And so if there's a problem with that, we can seek judicial review. Let's look at items 3 and 4. So the border force officer forming the view that the service revolver is a weapon, and as such is a prohibited import under section 67, and the border force officer forming the view that a Roman coin is counterfeit money and is prohibited. So section 67 is worded in such a way that if, in the opinion of the border force officer, an imported good is a dangerous good, the good is prohibited and they can be seized. Just based on the wording of section 67, do we think we're dealing with jurisdictional facts or non-jurisdictional facts here?
The wording indicates non-jurisdictional.
Yep, absolutely. The decision maker gets to decide if the good is a dangerous good or not, right? So now, not only are they getting to decide whether to seize the import or not, so that Z, which is the same as the previous section that we looked at, they're also getting to decide the precondition of whether they have the authority to act or not. So where in section 52, they don't get to choose if it's a restricted country or not. Now in section 67, they do get to decide if it's a dangerous good. So they get to decide yes or no, is it a dangerous good? And if they decide yes, then they get to decide what to do about it. So what does that mean from the perspective of judicial review then?
That you can only argue whether it fits into the description of what a dangerous weapon is, dangerous good is.
Tell me a little bit more about that.
Well, informing the opinion that it's a dangerous good, he may have regard to the following things, those 3 points. If your actual good doesn't fit into those 3 points, then you would have an argument to say that it was a jurisdictional error.
Would you?
Well, I think that again, it's hard because I know the Customs Act pretty well. It's like when you said they may seize it. It's because they have a policy that they can return it for a refund for the people. You can't just seize it if they have an option to return. But sorry, I'm just looking at this one and saying, well, the gun. There's also a thing that he says if you have a collector's license and the gun is unable to be fired, meaning that the thing's been plugged up in the barrel, then it's not considered a dangerous weapon. So it wouldn't fit into those 3 criteria. And the coin doesn't fit that criteria at all. So you could say that doesn't fit into a dangerous good.
Right. Well, so there's a few things here. The first being, these 52 and 67 are not the real 52 and 67 of the Customs Act. These are made up to, I suppose, illustrate the point. And I mean, the difficulty with pulling from real admin law statutes is that they're so layered that we'd spend all term on the one act, I think. But I take your point, right? And especially with something like customs and border security agents are given so many more options in deciding what to do. So that's a fair point. Thinking specifically about jurisdictional error and the issues around is it can we seek judicial review for this or not?
Well,
Subject.
I'd say the gun you couldn't if it's considered into that, but the coin I think you could.
Yeah. Anyone else wanted to weigh in?
Well, because it depends on the opinion of the Border Force officer, it becomes that second category of decision where they can decide whether or not it's a dangerous good. So then that would go back to the merits review process rather than judicial review. Potentially.
I mean,
if the act allowed for it, but because it gives the authorized person the ability to decide, it gives them the subjective opinion on whether it fits the category. There's less room for judicial review.
Yep. And that's so. And the key thing here is did they decide that it's a dangerous good, right? If they thought to themselves, no, I don't think this is dangerous, but we're going to seize it anyway, then procedurally there's an issue. But because the decision maker under the Act is given the power to decide whether an imported good is a dangerous good or not, immediately once they've decided, yes, I think that's a dangerous good, the court's ability to intervene on that jurisdictional element is pushed aside, right? It's a non-jurisdictional fact. Once the border force officer forms the opinion that it is a dangerous good, then for the purposes of jurisdiction, it is a dangerous good and they do get to act, right? They've decided, they are empowered under the Act to decide, and in this instance, they have decided that they have the authority to act. And so from a judicial review perspective, they do. From a jurisdictional error perspective, they do. Thinking about the difference between the gun and the coin and the things that the border force officer may have regard to in deciding whether something's a dangerous good or not. I think, Ian, your argument that, you know, the gun, it's pretty clear cut, you know, it's open to the decision maker to say, oh, look, here's a gun, that's dangerous. Yep, nothing to see here. You know, we can seize that. The issue around the coin, maybe we've got a bit more to argue here, right? In terms of really is a coin, for one, really is an ancient Roman coin counterfeit money, and for two, does that make it dangerous? The tricky thing is, in highlighting that issue, we're not arguing that the decision maker lacked jurisdiction. We can't say, hey, border force officer, you didn't get to decide whether this is a dangerous good or not. They're given that power. Instead, we're looking at different other grounds of review to say, I know you said that that's a dangerous good, but you don't really have any evidence to back that up. So thinking about our week 6 no evidence ground of review, or looking ahead to next week, we'll look at relevant considerations and irrelevant considerations, saying, you know, you saw that it was a coin, but did you actually look that, you know, it's very clearly not pretending to be Australian legal tender. It's you know, it's got Caesar's head on it. It's a Roman coin from 2,000 years ago. You didn't pay attention to the relevant things that you should have been thinking about, or you focused on irrelevant things. We'll talk about those grounds for review next week. But the key point being, it's still open to us to say, look, you made a mistake under subsection 2 of section 67. There are issues with the way that you went about deciding that it's a dangerous good, and we can attack and review from those angles. But it's not open to us to straight up say the decision maker lacked the authority to decide that it was a dangerous good. And lacking that authority wasn't allowed to seize the coin. We have to look for different avenues and different pathways that hopefully still reach the same destination, but it's just not open to us to attack that particular issue. And the reason being, the court, we've been talking about this all term in terms of separations of power. The court is so reluctant to stray into where Parliament has set up for the executive a clear ability to decide when it doesn't have jurisdiction. The court is not willing to interfere with that because that's staying firmly within the executive realm. Where Parliament, say under Section 52, has said, here's a clear boundary. This is when the executive can act, and this is when they can't act. The court is more than willing to compare the two and say, hang on, the Pokemon cards, they fall into the category of Parliament said you can't act. If it's an import from this country, it's not restricted. It's fine. They got no problem when it's nice and clear cut like that. But when Parliament gives the executive that discretion to choose when they can act, which, by the way, is most of the time, most statutes are worded in the way that gives the decision maker that flexibility. The court is not willing to intervene on that particular issue.
Well, with all that legislation, wherever they put the opinion of somebody or a police officer, only an expert can give an opinion, and that's the first thing that they pick on and say that, and that was why with the firearms and stuff, we used to have to go and examine them to make sure that they were actually fireable and all that sort of stuff. So when they put that opinion in there, it does open it up straight away to that sort of issue, that they're not an expert in their field.
Well, I mean, so there's what have I done here? There's and this is sort of the nature of academic assessment versus the real world is, we can only pack so much into an exam or a tutorial scenario that's reasonable for you to
No,
come up with an answer in a smaller time frame.
what section would that come under? What grounds would you use for that?
Or as in,
they're making an opinion and they're not an expert in that area. What if that was a ground of appeal? Because I know that's what they do, but I never understood what ground that would actually be under. Is that a ground that we discuss or not?
well, I mean, you mentioned police, which makes me think that really you're speaking about a more of a criminal matter than an administrative matter.
No. Under the Custom Act, they'd seize the firearms.
Okay.
We'd then have to go down and test the firearms because we did courses in guns and ammunition to be an expert in that area.
Yep.
But they did always argue that point. But I'm just wondering, like in this situation, because we don't have all that information, what ground of review would you use when? Because you said, like, when you say an opinion that you don't have it's a non-jurisdictional fact. But what is it then?
Well, you'd be looking at, and part of it will depend on, what are the other supporting provisions around it, and so for example, if the let's say paragraph 3 says that if in deciding that a weapon is a dangerous good, so looking at 2A, let's say section 3 further clarifies that in order to be classed as a weapon, it needs to be fireable, working, whatever the criteria that you've listed are. It might be that the view is that forms a procedure that needs to be followed, in which case we talked last week around a mandatory procedure not being followed would cause an issue with the decision maker's authority. We'll talk next week about relevant and irrelevant considerations. Potentially, you're forming an argument that where the statute sets out relevant considerations that have to go into the decision-making process, like whether it can be fired, whatever it is, a decision that doesn't take into account that expert evidence or those particular factors is flawed because the decision maker didn't consider a relevant consideration. Potentially that's a ground of review that we'd be thinking about. I mean, unreasonableness is always potentially there, but I wouldn't imagine that would succeed in this instance. So there's other options. I would think, depending on the wording, either procedures not followed from last week, or relevant and irrelevant considerations from next week, off the top of my head, would be the key ones that we'd be thinking about. But as always, the legislation is the key thing to focus on in guiding our answers. And that's why, in these scenarios, I try and give you legislation that's as simplified and clear as possible.
Yeah, and I understand. I'm not trying to put it into real life. There's a big lacking in my education of why we did things. That's why I'm trying to find out.
No, absolutely. And it's I suppose the way that I'm approaching this and trying to explain this is thinking about how do you need to be thinking about these issues in a way that is structured that will help you process the exam scenario, which is itself structured in a way that helps you think about it in the real world when there are extra layers of complexity layered on top of it as well. So yeah, and I think that's the trick, right? Is that you and a lot of other people have got a wealth of experience and lots of different backgrounds in lots of different areas, and yeah, oftentimes it is kind of breaking it down to the fundamental level and then building that experience back up on top of it. But yeah, absolutely. So yeah, I definitely appreciate the perspective and the questions. I'm conscious. Sorry, go ahead.
Like who sees the coin wouldn't be working there next week as a dangerous good. That's all.
Yes, and see, this is the thing, right? We can tell when there's a pretty a wonky decision. It's just a matter of identifying why it's problematic and identifying the right reasons and the right grounds of review to be arguing, and navigating the ones that are not open to us or that will be more difficult to prove or to argue, and those sorts of things. Look, I'm conscious that we've spilled over time. Thank you all very much for coming along this evening. Absolutely happy to keep this conversation running on Moodle or by email or into next week as well. But thank you all very much for coming along. Have a great week, and I'll see you all next week to talk about a few more grounds of review. So see you then. Thanks very much.